An inventive step is a requirement for a standard patent according to Section 18 of the Commonwealth Patents Act of 1990. In that section it states that a patentable invention must come within the meaning of Section 6 of the State of Monopolies, be novel, and involve an inventive step. Section 7, subsection 2 of the Patents Act goes on to elaborate on the requirements of an inventive step, highlighting the need for a comparison to a prior art base, the invention not to be obvious to a person skilled in the relative art, and a comparison of the common knowledge within the relevant field. It is these factors that will be discussed in this video. Prior art base is publicly available information within the relevant field. This information may be considered alone or with additional prior art information according to Section 7, subsection 3 of the Patents Act. The Patents Act gives a definition to invention in the dictionary found in Schedule 1. There we are told that invention means any manner of new manufacture the subject of letters, patent, and grant of privilege within Section 6 of the State of Monopolies, and includes an alleged invention. The principle taken from the case of Commissioner of Patents and Microcell is that patent cannot be granted in the case where a known substance has been combined with known properties for some new use only made suitable by the properties involved. In such a situation, there is a lack of ingenuity beyond routine human knowledge. Inventiveness has been the question of many cases over the years and has been found to exist in the following instances: where something new has been invented that involved ingenuity, a practical solution has resulted to a problem not yet overcome, suggestion of a new method of using known substances, and developing a new product. The courts have stressed that there only needs to exist a scintilla of inventiveness in order to support an inventive step. What is often the basis for these cases is whether the invention was obvious. Obvious takes the meaning of plain or very plain according to the Akzo Belogit case. When assessing whether an invention is obvious, the courts have given ample warning about using hindsight, insisting that it can oversimplify the process and lead to an incorrect conclusion. When using the hypothetical skilled person in the relevant art approach, the first process is determining the relevant art. Once this has been established, then it is important that the hypothetical skilled person be just that, skilled. Being an inventive worker is not a requirement. This may include a simple tradesman, a highly qualified scientist, or even a team of people, as was the case in Akzo Belogit. The principle of common knowledge was somewhat ambiguous until the case of Minnesota Mining and Manufacturing, commonly referred to as the 3M case. This decision, decided in the High Court of Australia in 1980, determined that common general knowledge refers to that which is known or used by those in the relevant trade. The term common general knowledge was then added as part of Section 7, subsection 2 of the Patents Act. It includes information found in standard educational or training courses in relevant fields, standard textbooks, technical manuals, dictionaries, magazines, or periodicals in the specific field. This element is considered on a case-by-case basis and is a question of fact. It needs to be determined whether something is adequately well known in the relevant field to be considered common knowledge to a person skilled in the art. If it has been decided that a standard patent claim lacks an inventive step, there may be grounds for opposition, re-examination, or revocation.